The list of companies that you can indisputably say changed the world is quite short. Microsoft is definitely on that list. In a few decades, computers went from being something only seen at large companies or in government offices to being on every desk and in every home in the developed world. Almost everything about our technology today can be traced back to the 80s and 90s, when computers stopped being a specialist tool and became a product anyone could use. Microsoft, more than any other player, successfully positioned itself at the industry's choke point. Control the platform and software that all these computers use, and you can control everything else. It didn't matter if you bought a Compaq, Dell, or HP computer, it came with Microsoft Windows on it. Microsoft beginning as a humble, scrappy startup is a bit of a myth. Bill Gates was born into a wealthy family and had plenty of access to computers in his youth, a rarity at the time. His mom was also on a board with the CEO of IBM, which probably led to Microsoft's first big break in 1980, a few years after its founding. IBM had always been the market leader in computing, but they had let the competition get ahead of them in the realm of personal computers. The company set the ambitious goal of developing and shipping a PC within the year. To do this, one of the components they needed was an operating system. After facing difficulties licensing from one of the bigger software companies of the time, IBM turned to Microsoft and tasked them with getting them an operating system. Microsoft doesn't actually build one themselves. They purchase QDOS, short for Quick and Dirty Operating System, from a company in Seattle and license it to IBM as the new PC-DOS. This licensing deal was pretty strange, however. Microsoft would be paid a simple flat fee for the operating system. In exchange, they would also be allowed to license it to anyone else that they wanted to, as MS-DOS. IBM didn't care about that last point. They simply assumed they would stay dominant in the hardware space, and software didn't matter. Nobody else would be able to compete anyway, right? Well, in IBM's haste to ship a personal computer, they had mainly used off-the-shelf components, things anyone could buy. This kept their costs low, but it also meant it was extremely easy for anyone else to copy and build their own IBM PC, maybe more famously known as the IBM clones. And, luckily for these clones, the company that makes IBM software is willing to sell that to them too. Suddenly, IBM is not actually dominant like they predicted, and are getting outcompeted by a slew of companies with computers running MS-DOS. Consequently, everyone also began writing software for MS-DOS, and it quickly became the de facto standard for computers. Microsoft essentially had a monopoly in the software space, with their operating system running on over 90% of all personal computers. Now, being a monopoly isn't illegal in the United States. If you legitimately offer a product that is better than what your competitors have, and this leads to your company dominating the market naturally, there isn't a crime. Where it does cross the legal line is when companies do sketchy things like collude to split up the market, or deliberately sabotage and suppress competition. The first legal investigation into Microsoft was opened by the Federal Trade Commission in June 1990. This was triggered by a joint press release IBM and Microsoft issued at the 1989 Comdex trade show in Las Vegas. This statement revealed a plan to essentially split the market in two, where customers who purchased high-end IBM computers would receive IBM's own OS/2 operating system, and low-end computers would get Microsoft's operating system, which was now Windows. In the eyes of the FTC, this was two companies that should have been competitors, instead teaming up to split the market. But while this was being investigated, Microsoft did something even more illegal by changing their licensing terms. The new terms required any PC manufacturer that wanted to sell Windows at all to pay Microsoft a fee per computer sold, even if the computer had no Microsoft products on it at all. The FTC saw this as Microsoft essentially penalizing manufacturers for using other operating systems. Companies would have to both pay Microsoft and whichever other operating system provider they chose. Ultimately, the Department of Justice made Microsoft sign an agreement to rework all of its licensing agreements to remove illegal stipulations like this. Crucially, Microsoft also no longer could tie products together, so they couldn't force computer makers to have to use Windows if they also wanted to offer Microsoft Office products, for example. Microsoft's lawyers did insist on a proviso that allowed them to keep selling integrated products, pieces of software that depended on each other. If this seems vague, that's because it was, and that was the point. Who was to say what was or wasn't an essential part of Windows? Microsoft didn't try to exploit this loophole immediately, but they kept it around, just in case. That just in case came sooner than anticipated as the internet began to change the entire landscape of computing in the mid-90s. Microsoft was well aware that the internet was going to be a big deal. Worryingly, however, it also threatened their monopoly. There were two products that Microsoft was terrified of: Java and Netscape Navigator. Netscape quickly became the most popular browser, and developers were increasingly offering applications that ran entirely within the browser. Suddenly it didn't matter that much if you were using Windows, it mattered a lot more if you were using Netscape. Java was a threat coming from the other direction. The whole selling point of Java was its write once, run anywhere structure. It didn't matter what the underlying operating system was, everything ran inside Java's own virtual machine. Microsoft's whole monopoly was that developers had to write software specifically for Windows. Suddenly, there were a lot of easy ways to write software that worked on anything. It was a pretty fundamental threat to Microsoft's entire business model. Bill Gates declared the internet to be Microsoft's top priority, and an internal memo literally called on Microsoft to wage a jihad to win what was now being called the browser war. I'm not kidding, they really called it a jihad. Microsoft's next major product release, Windows 95, actually launched without a browser at all. Microsoft's browser, Internet Explorer, was only part of the Microsoft Plus expansion. Soon enough, though, Microsoft began demanding that computer makers bundle in Internet Explorer if they wanted to ship Windows at all. Microsoft claimed this was because Internet Explorer was now an essential part of the operating system, and that it was now legal for them to bundle these two products together. Soon after, in 1997, Microsoft approached Apple, which was very much struggling at the time. Microsoft offered them a deal where they would provide $150 million of investment and would support Microsoft Office products for Mac for 5 more years. In return, Apple had to make Internet Explorer the default browser on all of their computers. While this was a significant investment in a direct competitor and ultimately saved Apple, the Department of Justice really wasn't happy with Microsoft. Bundling Internet Explorer with Windows 95 was seen as a violation of the previous agreement. The Department of Justice petitioned that Microsoft was in contempt and to fine them $1 million per day as long as the violation continued. The judge presiding over the federal district court, Judge Thomas Penfield Jackson, denied this request, however. He felt that there wasn't enough evidence that Microsoft had clearly and unambiguously broken the agreement. However, he did order Microsoft to stop forcing manufacturers to bundle Internet Explorer in with Windows. Microsoft responded to this injunction with malicious compliance. Original equipment manufacturers were given two choices: get a version of Windows 95 that was 2 years behind on updates and lacked a ton of features that customers were expecting, or get a version that Microsoft had deliberately broken by removing essential system files. Judge Jackson found this reaction strange. Upon testing with his own computer, he was able to uninstall Internet Explorer in less than 90 seconds without breaking any system functionality, as Microsoft had claimed. Convinced that Microsoft was going to use every legal loophole they could find, the Department of Justice and 20 state governments, mostly states where Microsoft's competitors were based, brought another lawsuit. This case landed right back on the desk of Judge Thomas Penfield Jackson. Judge Jackson was quite the character, and he as a person greatly shaped how the trial played out. A physically imposing man, he was known for being blunt and strict in running the courtroom. He was also deeply pragmatic, and recognized he was pretty out of his depth in dealing with a case primarily about software, often leaning on his younger law clerks to explain things to him. He knew that in the tech industry, things move fast. Previous antitrust cases against tech giants like IBM and AT&T had dragged on in the courts for over a decade each, and had devolved into years of legal trench warfare. Judge Jackson implemented several measures in the Microsoft case that were called creative to expedite the trial. A preliminary hearing about the case was skipped entirely, surprising all sides by scheduling the trial to start in just 4 months. Each side, Microsoft and the states, would only be allowed to call 12 witnesses each. All testimony had to be submitted in writing ahead of time, and courtroom time would be strictly for cross-examination only. Bill Gates himself didn't appear in person for the trial, instead being deposed on video recordings by the Department of Justice's lead litigator, David Boies. It lasted 20 hours, over several days, and was extremely damaging to Gates's credibility. He was rude, argumentative, and exceedingly pedantic throughout the entire process. He would frequently derail the entire thing by arguing about the definition of basic words like ask, or compete, or we. He would do things like claim he couldn't talk about a memo because the document in question was actually an email. He even argued with Boies about the definition of the word definition while smirking the entire time.
Must have been a common understanding. I wouldn't say a definition.
How would that common understanding have been arrived at, other than through a definition?
Oh, somebody can give examples. I'm just saying there doesn't have to be a formal definition for two people to have a context in a conversation of what a word means. That is, neither one has to say, I define the word as follows. So maybe I interpreted your use of the word definition too strictly.
Okay.
So if you define definition for this conversation in a loose way, then I'll understand what you mean.
Gates was known for being very hands-on, even micromanaging, as a boss at Microsoft. During this deposition, however, he was suddenly unusually forgetful and seemingly unaware of what was going on at his own company. In the 684-page transcript, Gates used the phrases, "I don't recall" or "I don't remember" over 200 times. He would frequently sit completely silent for long periods of time after being asked a question, only to respond with a reply like, "I didn't write that email, how could you expect me to know what they were talking about?" Judge Jackson issued a surprise reversal during the course of the trial, allowing videotaped depositions to be played in the courtroom. Gates likely assumed the deposition would only be used as a text-based transcript, and his demeanor shown on tape turned public opinion decidedly against him and his company. There was plenty of other damaging evidence brought to the trial too. Internal emails and memos within Microsoft painted an image of the company as a ruthless monopoly, determined to sabotage any competitors. Some specific quotes included a plan to cut off Netscape's air supply and a strategy to leverage the OS asset to force users to use Internet Explorer. Microsoft's plan to kill Java was also revealed. They had created a bunch of development tools for Java specific to Windows, including a special Windows-compatible version of the Java Virtual Machine. Programs specifically written for this Windows version, however, could not be run on any other platforms, defeating the whole point of Java. Microsoft deliberately hid this information from developers, meaning people thought they were writing code that could be ported elsewhere, but couldn't. Microsoft internally referred to this as polluted Java, and there was even an email stating they wished to kill cross-platform Java by growing the polluted Java market. It was also uncovered that the deal between Microsoft and Apple wasn't exactly the result of fair negotiations. Microsoft had threatened to immediately pull all Office products from Macs if Apple didn't agree to the deal. Considering this would have made Macs essentially useless to anyone doing serious work on them, Apple really didn't have much of a choice but to go along with it. Steve Jobs only managed to get the $150 million investment from Microsoft by leveraging the pressure they were already under from the Department of Justice. Microsoft's internal documents also corroborated the claims made by many prosecution witnesses. Netscape's CEO, Jim Barksdale, was the first witness called to testify. He described how Microsoft had actually approached Netscape fairly early on in 1995 and offered them a special relationship. Netscape was essentially told to stay away from developing a browser for Windows 95, and in exchange, Microsoft would invest in the company and offer tight integration with Microsoft technologies. Microsoft's internal emails described this as a plan to suck the functionality of Netscape into Windows itself and to love Netscape to death. Netscape, recognizing this collusion would be super illegal, declined Microsoft's offer and instead reported it to the Justice Department. Of course, Microsoft saw all of this evidence and the entire situation very differently. Microsoft claimed they were merely competing in the highly competitive software industry, and any competitor could easily leapfrog them with a single killer app. Additionally, Microsoft did hold many copyrights related to its software, and any activities that might have been construed as anti-competitive were instead merely enforcement of the company's intellectual property rights. Besides, what was the issue with Microsoft giving consumers a free browser anyway? Not Microsoft's problem their competitors couldn't write better code. If anything, they might be in the wrong for bringing a lawsuit just because they couldn't ship a better product. Finally, Microsoft also challenged the Sherman Antitrust Act itself, claiming a law from 1890 couldn't properly regulate the modern software industry. These arguments were not persuasive. Judge Jackson's finding of fact agreed with the prosecution's account of events. However, he deliberately held off from making a legal ruling for a few months as part of a last-ditch effort to get the two sides to negotiate. Judge Richard Posner of the 7th Circuit Court of Appeals was appointed to mediate secret negotiations between Microsoft and the plaintiffs. Judge Posner held repeated meetings with Bill Gates and other Microsoft executives, attempting to draft various plans that would have opened up Windows as a platform and limited the company's power to control what applications could be made for Windows. The Justice Department and the states, however, were very loudly and publicly demanding Microsoft be broken up into 3 companies. These would be a company for Windows 2000, a company for all previous Windows versions, and a company for Microsoft's applications like Office. The states thought Judge Posner was being too soft on Microsoft, and kept adding more demands during the negotiations. Microsoft, meanwhile, was willing to cooperate on some of the proposed terms, even going as far as offering to license Windows source code, which would have made Windows far more accessible. However, the states kept demanding Microsoft be broken up, something the company absolutely refused to entertain. The new Microsoft CEO, Steve Ballmer, described it as reckless beyond belief, and the negotiations were ultimately ended after 4 months due to deep-seated disagreements that could not be bridged. With no hopes for the sides to reach a last-minute deal, Judge Jackson issued his legal ruling in April of 2000. Microsoft is in violation of the Sherman Act for illegal product tying and monopolist practices. Microsoft was ordered to be broken up into 2 separate companies, one for their operating systems and one for their applications. Microsoft immediately appealed this decision. The company had 2 plans here, either win on appeal directly or drag the case out past the 2000 election and hope the new administration would be more friendly towards them. Luckily for them, they got both of their wishes. George W. Bush won the 2000 election and brought new leadership to the Department of Justice. This version of the department would be much more pro-business, and the idea of breaking up one of America's biggest tech companies was simply not going to happen. Before Bush even got into office, the attorney he picked to head the department's antitrust division, Charles James, stated any remedy would be limited to business conduct restrictions only. The Bush administration's Department of Justice would even defend Microsoft from later lawsuits they faced internationally in South Korea and the EU. The D.C. Circuit Court of Appeals, upon reviewing the case, threw out Judge Jackson's breakup order. While the court did agree with both his findings of fact and law that Microsoft was a monopoly, they disagreed that splitting up the company would be the best solution. Furthermore, they disqualified and removed Judge Jackson from the case entirely, and all future proceedings would have to be under a different judge. It had been revealed after the breakup verdict had been delivered that Judge Jackson had held secret meetings with reporters in his private courtroom chambers, where he had been less than impartial. He compared Microsoft to a drug-dealing gang that was murdering people that denied their crimes even in the face of overwhelming evidence. He described Bill Gates as a smart-mouthed young kid that needs a little discipline, with a Napoleonic view of himself. In justifying his breakup order, he called Microsoft a stubborn mule that needed to be hit on the head with a 2x4 to get his attention. On Microsoft's attempts to avoid being broken up, he likened their conduct to Japan at the end of World War II, trying to negotiate terms when they had been obviously defeated. Judge Jackson thought he was in the clear legally with all these comments because he had told the reporters not to publish them until the case had concluded, which is not how the law works. A judge very obviously having a favorite side in a case is simply not allowed. The D.C. Circuit Court of Appeals described his conduct as deliberate, repeated, egregious, and flagrant violations of the Judicial Code of Conduct. His comments gave the impression of a judge posturing for posterity, trying to provide journalists with catchy quotes rather than maintain neutrality. A new negotiated settlement to the case was reached in November of 2001, which was much less harsh. Microsoft had to standardize the license for Windows, meaning they couldn't offer special deals to loyal partners or penalize manufacturers that offered competing software. Microsoft also had to share technical information about its programming interfaces, meaning rival software developers could significantly increase the performance of their programs developed for Windows. An independent technical committee of about 50 engineers was also established to monitor Microsoft's compliance with the terms. This committee was only supposed to last until 2006, but stuck around until 2011 due to Microsoft's delays in implementing the conditions of the settlement. So, what actually changed? Not much. Internet Explorer did pretty much win the browser wars, and Netscape Navigator was mostly dead by the time the settlement was reached. Without any serious competition, however, Internet Explorer stagnated badly, becoming a synonym for a slow, outdated product by the mid-2000s. New browsers, like Firefox and Chrome, steadily ate into Internet Explorer's market share and eventually displaced it. The product Microsoft fought so hard for eventually became a joke, the thing you only use to download another browser. The case is sometimes framed as a failure, a slap on the wrist for Microsoft after years of anti-competitive business conduct. But the timing is crucial. Microsoft was unusually cautious and timid during the crucial 2000s, when the internet truly took off. Google, Amazon, and others were just getting started, and Microsoft pretty much stayed out of it. Whether this caution was a direct result of the case is hard to prove, but the timing is hard to ignore. The questions the case raised are hard to ignore. Can a law from 1890 really regulate modern industry? How do you punish a monopoly without also punishing success? Where is the line between being a strong competitor and weaponizing market dominance? These questions are not settled, and we'll probably be talking about them again soon enough.
Developers.